If you are a green card holder residing in the United States right now, stop everything you are doing and pay close attention to what I'm about to share with you. A brand new immigration regulation just passed today. And depending on your situation, this could either be the best news you have heard in years, or it could put your entire future in this country at serious risk. I am not exaggerating. I am not trying to frighten you unnecessarily. This is occurring right now. And millions of green card holders across America need to understand exactly what this means for them before it is too late. You see, while most people were going about their normal day, something major occurred in Washington that flew completely under the radar. A new immigration regulation was quietly passed. And trust me when I say this, the consequences are massive. Some of you watching this video right now will breathe a huge sigh of relief by the conclusion. Others might need to take immediate action to protect everything you have worked so hard to build. The difference between these two outcomes comes down to one thing: whether or not you have the right information. Welcome back to U.S. Policy Brief, your #1 source for the latest and most accurate United States immigration updates. I am your host, Fernando. If you are new here, hit that subscribe button right now, because the information I share on this channel could literally transform your immigration journey. I post updates every single week, breaking down complex immigration laws into simple, actionable steps. Now, let us get straight into what you really came here for. Before I reveal exactly what this new regulation contains, I need you to understand something important. This is not like other immigration updates. This regulation has teeth. It has consequences, and it is going to be enforced starting sooner than most people realize. Over the next few minutes, I will explain what modified, why it modified, who this affects the most, and what steps you should take starting today. Here is where things get interesting. The new regulation specifically targets green card holders who have been living a certain way that the government has decided is no longer acceptable. Before you start worrying, let me be clear. If you are a green card holder who resides in the United States full-time, who works here, pays taxes here, and has built your life here, you probably have nothing to worry about. Some parts of this new regulation might actually benefit you, but if you fall into certain other categories, you need to listen very carefully. The United States government has been watching patterns among green card holders for years. They have collected data and analyzed behaviors. There are some green card holders who obtain their permanent resident status, but do not actually reside permanently in the United States. They come back once or twice a year, stay for a few weeks, and then depart again. They maintain an address here, maybe a bank account, but their real life is somewhere else. For years, this was a gray area. The regulations existed, but enforcement was inconsistent. That era is officially over. What makes this new regulation different from anything we have observed before is the level of enforcement that comes with it. This is not just a policy memo. This is a fully funded regulation with real consequences attached. The government has allocated significant resources to track green card holder travel patterns, residency claims, and tax filings. They are connecting databases that were previously separate. They are utilizing technology in ways that make it nearly impossible to fly under the radar anymore. But here is something most other channels will not tell you. This regulation is not designed to punish people who are following the rules. It is designed to ensure that permanent resident status actually means permanent residence. The government is saying, we gave you this incredible privilege of residing and working in the United States, and we expect you to actually utilize it. That is the logic behind this regulation. I understand many of you are worried. You might be thinking about that time you had to depart the country for 6 months to take care of a sick family member. You might be remembering years when your job required you to work overseas temporarily. I understand that worry. That is exactly why I'm going to break this entire regulation down piece by piece, so you understand exactly where you stand. The new regulation creates several different categories of green card holders, and your category determines what occurs to you. If you fall into what the government is calling the compliant category, meaning you have maintained continuous residence with only normal trips abroad, you have nothing to worry about. Your green card is safe. Your path to citizenship remains clear. But if you fall into the review category or the violation category, things get more complicated. Let me start with the first major modification. The new regulation tightens the definition of what counts as abandoning your permanent residence. Under the old system, you could technically stay outside the United States for up to 1 year before your green card was considered abandoned. And even then, enforcement was inconsistent. Officers at the border had discretion. Some people got through without questions. Others faced problems. There was no uniformity. The new regulation modifies all of that. Under the new regulation, the threshold for triggering a residency review has been lowered significantly. Previously, you could spend up to 12 months outside the United States before your green card status came into question. Now, that window has been reduced to just 6 months. Let me repeat that because I understand some of you might have missed it. 6 months. If you spend more than 180 days outside of the United States in a single trip without proper documentation, your green card can now be flagged for immediate review upon your return. But here is where it gets even more serious. The new regulation does not just examine individual trips, it examines patterns. The government will now analyze your travel history over a rolling 3-year period. If they determine that you have spent more time outside the United States than inside over that 3-year window, even if no single trip exceeded 6 months, you could still be placed in the review category. This is a complete game changer. This means people who thought they were being clever by taking multiple shorter trips are no longer safe. Let me provide you a real example so you understand how this works. Imagine a green card holder who travels to their home country 4 times per year, staying for 2 months each time. That adds up to 8 months abroad per year. Over 3 years, that person has spent 24 months outside the United States and only 12 months inside. Under the old system, this person might have been questioned at the border occasionally, but they usually got through. Under the new regulation, this person is automatically flagged for residency review. Their green card renewal could be denied. Their path to citizenship is now blocked, and in extreme situations, removal proceedings could begin. Now, I want you to take a deep breath, because I understand this sounds scary, but here is the important part. The government is also introducing a way for people to protect themselves if they have legitimate reasons for extended absences. This is where the new documentation requirements come in. Starting immediately, green card holders who understand they need to spend extended time outside the United States can apply for what is being called an extended absence authorization. This is similar to the old re-entry permit, but it has been modernized and streamlined. The application process is now entirely online. Processing times have been reduced to approximately 60 days for most cases, and the authorization can cover absences of up to 2 years in certain circumstances. Here is what you need to understand about qualifying for this authorization. You must apply before you depart the United States. Let me emphasize that before you depart. If you are already outside the country and you suddenly realize you need to stay longer, you cannot apply for this authorization from abroad. The application must be submitted while you are physically present in the United States. This is a strict requirement with no exceptions. The qualifying reasons for extended absence include medical emergencies involving immediate family members abroad, employment assignments from United States-based companies, educational programs that require overseas study, and military or government service obligations. If your reason falls into one of these categories and you have proper documentation, you can protect your green card status even during extended absences. But here is where things get interesting for those of you who do not have a qualifying reason. The new regulation introduces something called the ties assessment test. This is a formal evaluation that border officers and immigration adjudicators will now utilize when deciding whether a green card holder has maintained their permanent residence. The test examines multiple factors and assigns points based on how strong your ties to the United States are. The factors include whether you maintain a primary residence in the United States, whether you are employed by a United States-based company, whether you file United States tax returns as a resident, whether you have immediate family members residing in the United States, whether your children attend school in the United States, whether you maintain bank accounts and financial assets in the United States, and whether you are registered to vote in local or state elections where eligible. Each factor is assigned a point value, and your total score determines which category you fall into. If you score above a certain threshold, you are considered to be in good standing regardless of your travel patterns. If you score below that threshold, your case will be referred for additional review. This is actually good news for people who genuinely reside in the United States, but have to travel frequently for legitimate reasons. It means the government is examining the full picture, rather than just counting days. Now let me discuss the enhanced monitoring systems because this is something that affects every single green card holder, whether you travel frequently or not. The government has implemented new technology that tracks entries and exits automatically. Previously, the United States had good records of when people entered the country, but inconsistent records of when they departed. This created gaps in data that some people exploited. Those gaps no longer exist. Every time you depart the United States, your departure is now recorded in real time. Every time you return, your entry is matched against your departure record. The system automatically calculates how many days you have spent abroad. It flags patterns. It generates alerts. And all of this information is now accessible to border officers, immigration adjudicators, and citizenship examiners. What does this mean practically? It means you cannot hide your travel patterns anymore. When you apply for citizenship, the examiner will pull up your complete travel history with a single click. When you try to renew your green card, the adjudicator will observe exactly how many days you have spent outside the United States over the past decade. When you return from a trip abroad, the border officer will already understand how long you were gone before you even hand over your passport. Some of you might be thinking, this sounds invasive. I understand that reaction, but examine it from the government's perspective. Permanent residence is a privilege that millions of people around the world desperately want. There are people waiting in line for decades hoping to obtain a green card. The government believes that if you have this privilege, you should actually utilize it. You should actually reside here. And if you do not want to reside here, then perhaps that green card should go to someone who does. Now, here is something that is going to affect every single green card holder in the United States, regardless of how much you travel. The new regulation introduces a mandatory annual confirmation of residence requirement. This is completely new. Nothing like this has ever existed before in United States immigration law. And if you fail to comply, the consequences are serious. Starting 6 months from the date this regulation was passed, every green card holder will be required to file an online confirmation form once per year. The form is simple. It takes about 10 minutes to complete. You will confirm your current address, your employment status, your tax filing status, and certify that you are maintaining continuous residence in the United States. You will also be required to upload a recent utility bill, bank statement, or similar document that proves you are actually residing at the address you claim. The deadline for filing this confirmation will be based on your birth month. If you were born in January, your confirmation is due every January. If you were born in July, your confirmation is due every July. The government designed it this way to spread out the workload across the entire year, rather than having millions of people filing on the same date. Here is where most people are going to make mistakes. If you fail to file your annual confirmation within the required window, your green card status will automatically be placed on administrative hold. This does not mean your green card is revoked immediately, but it does mean you will face problems. If you try to re-enter the United States while your status is on hold, you will be pulled aside for secondary inspection. If you try to apply for citizenship, your application will be delayed until the hold is resolved. If you try to renew your green card, your renewal will be denied until you come into compliance. The good news is that resolving a hold is relatively straightforward if you act quickly. You will need to file the overdue confirmation along with a late fee of approximately $200. You will also need to provide an explanation for why you missed the deadline. If your explanation is reasonable and you have no other compliance issues, the hold will typically be lifted within 30 days. But if you ignore the hold and let it linger for more than 12 months, your case will be referred for formal residency review. Let me explain exactly what occurs during a residency review, because this is where things get very serious. A residency review is a formal process where an immigration adjudicator examines your entire history as a green card holder to determine whether you have abandoned your permanent residence. This is not a casual interview. This is an adversarial proceeding where the burden of proof is on you. During the review, you will be required to provide extensive documentation, tax returns for the past 5 years, employment records, lease agreements or mortgage statements, utility bills, bank statements, school records for your children, medical records showing treatment in the United States, insurance policies, vehicle registrations, anything and everything that proves you have been residing in this country. The adjudicator will analyze all of this evidence along with your travel history and your annual confirmation filings. You will also be interviewed under oath. The adjudicator will ask detailed questions about your life. Where do you sleep most nights? Where do you keep your personal belongings? Where is your doctor? Where is your dentist? Where do you buy groceries? Where do you worship? Who are your neighbors? What community organizations are you involved in? These questions are designed to determine whether you actually reside in the United States or whether you just maintain a token presence here. If the adjudicator determines that you have not abandoned your residence, your case is closed and you can continue with your life. But if the adjudicator determines that you have abandoned your residence, the consequences are severe. Your green card can be revoked. Your path to citizenship is permanently blocked unless you start the entire process over from the beginning. And in some situations, you can be placed in removal proceedings, which means deportation. Now, I need to discuss who is most at risk under this new regulation, because some of you watching this video are in serious danger, and you might not even realize it. Let me describe the profiles of people who should be most concerned. The first group is what I call the split residence green card holders. These are people who obtained their green cards through family sponsorship or employment, but never fully transition their lives to the United States. They keep their primary home in their birth country. Their spouse and children might still reside abroad. They come to the United States periodically to maintain their status, but their real life is somewhere else. If this describes you, you are in the highest risk category under this new regulation. The second group is retirees who have gone back home. These are people who worked in the United States for decades, obtained their green cards, maybe even raised their children here, but then retired and moved back to their home country to be closer to extended family or to enjoy a lower cost of living. Many people in this situation assumed their green card would remain valid as long as they visited the United States occasionally. That assumption is no longer correct. The third group is business owners with international operations. These are entrepreneurs who run businesses that require them to spend significant time overseas. They might have offices in multiple countries, they might have manufacturing facilities abroad, they might have clients who require in-person service in other parts of the world. Even though their business headquarters might be in the United States, their physical presence often is not. This group needs to be very careful about documentation and should strongly consider applying for extended absence authorization before any lengthy trips. The fourth group is people with elderly or sick parents abroad. This is perhaps the most sympathetic category. These are green card holders who have been spending extended time overseas to care for aging parents or family members with serious illnesses. Their hearts are in the right place. Their intentions are good, but good intentions do not protect you from immigration consequences. If you are in this situation, you need to take proactive steps immediately to document your reasons for extended absence. The fifth group is remote workers who decided to work from abroad. This became extremely common during the pandemic. Many green card holders whose jobs went fully remote decided to spend extended periods working from their home countries. They continued working for United States companies. They continued receiving United States paychecks. They continued paying United States taxes, but their physical bodies were not in the United States. The new regulation makes clear that remote work from abroad does not count as maintaining residence in the United States. If you fall into any of these 5 categories, please do not panic. There are steps you can take to protect yourself, but you need to take those steps immediately. You cannot wait and hope this regulation does not apply to you. You cannot assume that you will somehow slip through the cracks. The new monitoring systems are specifically designed to identify people exactly like you. So, what should you do right now if you are concerned about your status? Let me provide you a clear action plan that you can start implementing today. First, gather all of your documentation. Collect your tax returns, employment records, lease agreements, utility bills, and any other evidence that proves you have been residing in the United States. Organize these documents by year so you can quickly demonstrate your residence history if you are ever questioned. Second, calculate your travel history. Go through your passport and add up exactly how many days you have spent outside the United States over the past 3 years. Be honest with yourself. If the number is higher than you expected, you need to start building a stronger paper trail of your United States residence immediately. Third, if you understand you will need to travel abroad for an extended period in the future, apply for extended absence authorization before you depart. Do not wait until the last minute. Do not assume you will be fine without it. The application process takes 60 days, so plan accordingly. Fourth, set a reminder for your annual confirmation filing. Put it in your calendar right now. Set multiple reminders. This is not something you can afford to forget. Missing this deadline creates problems that are entirely avoidable. Fifth, consult with an immigration attorney if you have any doubts about your situation. I provide general information on this channel, but I cannot give you personalized legal advice. Every case is different. An experienced attorney can review your specific circumstances and tell you exactly where you stand. Now here is the good news that I promised at the beginning of this video. For those of you who are fully compliant, who reside in the United States full-time, who work here and pay taxes here, and have built your entire lives here, this new regulation actually benefits you. It clears out the backlog of green card applications by removing people who are not utilizing their permanent resident status properly. It speeds up processing times for citizenship applications, and it reinforces the value of the privilege you hold. Your green card is not just a piece of plastic. It represents an opportunity that billions of people around the world would do anything to have. It represents the chance to build a life in the greatest country on earth. It represents hope and possibility, and the American dream. The government wants to make sure that everyone who holds this privilege actually appreciates it. I understand this video contained a lot of heavy information. I understand some of you might be feeling anxious right now. But remember, knowledge is power. By watching this video, you are already ahead of millions of green card holders who have no idea this regulation even exists. Utilize this knowledge wisely. Take action immediately. Protect yourself and your family. Now, I want to hear from you. Where are you watching this video from right now? Are you a green card holder, or are you still working toward obtaining your green card? How do you feel about this new regulation? Drop a comment below and let me know. I read every single comment personally, and I respond to as many as I can. If you found this video helpful, hit that like button and share it with any green card holders you understand. They need this information too. Subscribe to US Policy Brief and turn on notifications so you never miss an important immigration update. I am Fernando, and your future depends on staying informed.